Good morning, Miss Sonia. My name is Penelope. I'm here to get some advice from you. So last week, me and Marcus have entered into a license agreement with Aaron for a basement flat. In that agreement, he stated that we have to pay a license fee of 1,000 per month, and it should last until England wins the World Cup. And also, he added some conditions that he shall enter the premises, the property, to remove recycling every Friday afternoon, and we should leave the property every Saturday afternoon for him to use it for his choir practice. And last week, he sold the property to Zane, and now Zane wants us to leave the property by the end of the month. Please advise us on the challenges that we might face in this situation. Good morning, Ms. Penelope. My name is Sonia, and I'm here to advise you on the key challenges that you will be facing in this situation and give you some recommendations to solve your issue. The first challenge is to distinguish the agreement between you, Marcus, and Aaron, whether it amounts to a lease or a license. The agreement between the parties now is named as license agreement. First of all, a leasehold is found under Section 1B of the Law of Property Act 1925, or known as LPA 1925, where it could be one of the estates that is competent to be conveyed by law. And also, the definition of leasehold is expressly stated in Section 205 of LPA 1925, where the terms of use absolute means the lease granted should be for a duration that begins immediately or in the future and can be terminated by a notice. Whereas a license means a permission given by a licensor to a licensee to use his property for specific purposes only. Plus, a license is more of a personal agreement rather than propriety, which is registered under the Land Registration Act 2002, also LRA 2002. So, according to Lord Justice Millett in Burton and London Quadrant Housing Trust, no matter what the party's intention may be in an agreement, the legal outcome of it would determine whether it's a tenancy or a lease. Hence, there are certain requirements that should be fulfilled for an agreement to be a tenancy, which was famously cited by Lord Templeman in Street and Mountford, where exclusive possession must be given to the occupier for a certain period of time in exchange for a fee or a monthly payment in order for that to be a tenancy. So let's break it down. So the first element here is exclusive possession. A person who's let into exclusive possession is regarded as tenant, which means there is an intention to create tenancy. In Arslan and Murphy, the landowner signed an agreement with the occupier without granting exclusive possession, sharing the room with other licensees, and retaining the keys for the room. This was regarded as a sham clause by the court to avoid granting exclusive possession, and the landowner retaining the keys for emergency and inspection purposes that instead of providing daily services does not mean that there is no exclusive possession. Similarly, in this case, Aaron had retained his rights to enter the premises every Friday afternoon to remove recycling. This means that you and Marcus have only exclusive occupation that is granted to a licensee instead of exclusive possession. And note that in the case of Marcus and Marcau and Da Silvesa, the court viewed that a mere promise of providing daily services does not make an agreement a license. Instead, it must be actually provided. In addition, to show this criteria, you and Marcus should be able to prove that you have effective control of the basement flat, because exclusive possession also entails exclusive control. This test was established in the case of Wells and Kingston, where the corporation had let the dog to the ship owners, and with condition that opening and closing the dock is the responsibility of the corporation, and the ship owners must clean the docks with the supervision of the corporation. The court ruled that the letting the dog to the ship owner is just a license because general control was not provided to the ship owners. Therefore, it is evident that the requirement for exclusive possession is only disregarded in cases where the landowner has unlimited access to the property. It is in the present case, you and Marcus are deprived of exclusive possession because Aaron still has full control of the premises by entering and exiting the premises. The next criteria is rent. So this is an arguable criteria because it was stated by Lord Templeman that to an agreement to amount to a tenancy there should be a rent, but it's not actually a statutory requirement, as can be seen in section 205 of LPA 1925, where the terms of use absolute means for a terms of use whether or not rent. Similarly, Justice Windeyer in Radich and Smith also viewed that the basic right of a tenant to be distinguished by a licensee is exclusive possession of a land for a specific period continuously over time for a life. He clearly did not state the word rent. So when is rent required? To be eligible for statutory protection, certain type of leases requires to be secured by rent, and this is what was highlighted by Lord Templeman. Under the Rent Act 1977, it provides the private tenants a specific status of irremovability, and a fair rent is required as exchange for a security of tenure. It is a common misconception that non-payment of rent will result in no tenancy. Nonetheless, parties these days enter into license agreement to avoid the consequences of the Rent Act. This is because licensees have limited protection in this act. Hence, you and Marcus were to pay £1,000 each month as a license fee does not amount that there is no rent. The final ingredient is a term certain. Basically means for a certain period of time. As mentioned in section 205 of LPA 1925, a duration of a lease must be fixed and certain. In the case of Leys and Chandler, the tenant was granted a lease until the duration of war. The court viewed that this is not a fixed lease because it was impossible to predict when the war is going to last, and this was reaffirmed in the case of Prudential Assurance and London Residuary Body, where the granting of land until it was acquired for road widening would not create a tenancy. Similarly, in this case, you and Marcus have been granted a license agreement until England wins the World Cup. This certainly does not create a fixed lease because it was impossible to predict when England is going to win the World Cup, and it is obviously stated in section 149 subsection 6 of LPA 1925. Leases for life is now exchanged to leases of 90 years and terminable by death, which makes the previously unclear terms specified. On the question whether this amounts to a periodic tenancy is always speculative, as the maximum duration of this tenancy is unpredictable, and because no one knows when it will begin and how long it will last. In Prudential case, the court rejected the view for periodic tenancy because there was no clear express bargain for the tenant to keep using the temporary structures of the land as long as the land was required for road widening. Similarly, you and Marcus will not be able to claim for periodic tenancy. Rather, the situation is more like a license than a tenancy at will. Basically means it does not matter whether the there is rent payment for every month or not. The essential ingredient is the substance of the agreement. In this case, it was clear that Aaron did not intend for the agreement to be a lease. The second challenge is whether this will come into the scope of equitable leases. First of all, it is important to distinguish between legal leases and equitable leases. A legal lease is created under the guidance of rules set out in statutes. It should be made by deed to be valid as stated in section 52 subsection 1 of LPA 1925. Moreover, the document must expressly state that the word deed. Nonetheless, in this case, Aaron did not make any mention of a deed but instead used the term license agreement. Since it was not created by deed, you and Marcus cannot rely on the contractual remedies available for legal leases such as damages. If there is no compliance to legal leases, it could be recognized as equitable lease. And this is affirmed in the case of Walsh and Lonsdale, where such informal leases is as good as a lease in equity. An equity lease will prevail over periodic tenancy since all the original clauses are existing and because presumably for a longer duration. Equity leases are created by a signed written document between the parties, and they may depend on specific performance to enforce the contract. In the present case, you and Marcus have entered into a written agreement with Aaron. This could amount to an equitable lease and may depend on specific performance. However, there are certain requirements to be met to rely on specific performance to enforce the contract. The first ingredient is the agreement must be of valuable consideration, like rent. And this was satisfied by you and Marcus by paying monthly payments of £1,000 each month. And the second requirement is the agreement must be in written agreement as stated in Section 2 of the Law of Property Act 1989. And this was satisfied by signing the license agreement as the parties intend to treat the agreement as a valid contract. The third requirement is the claimant must come in clean hands. That is, you and Marcus must come into equity with clean hands. This can be explained by evaluating the case of Cosworth and Johnson, where the claimant entered a lease with the landowner with conditions to maintain the farm in good manner, but he had deteriorated the farm badly. The court refused to apply equitable remedy, that is specific performance in this case, because the tenant has come into equity with unclean hands. Hence, Lord Asher stated, there will be no lease if the court of equity had not decreed a specific performance. In the present scenario, you and Marcus can rely on equity if you have come with clean hands, and the agreement should be with valuable consideration and in written form, and hence apply specific performance to enforce the contract. The last challenge is whether this equitable lease will bind new purchasers, that is in this context Zane. Once Aaron had sold the property to Zane, it must have triggered the registration under Section 4 of Land Registration Act 2002. Hence, equitable lease will take effect as an overriding interest which binds the new purchaser, provided that the tenant is in actual occupation of the property under Schedule 3, Paragraph 2 of LRA 2002, which lists out the interests of persons in actual occupation. Therefore, you and Marcus must remain in occupation to secure your rights on the basement flat, This meant that Zain will be bound by equity to continue the agreement. Additionally, it is viewed by the court that the inclusion of equity means that contractual licenses have now their own force and validity and cannot be terminated by violation of contract, except for purchases for value without notice. In conclusion, the main requirements, which are the hallmark of tenancy, that is exclusive possession and a term certain, is not satisfied. Hence, the agreement between you, Marcus, and Aaron will not amount to a lease but a license, which meant that you have actual exclusive occupation of the property rather than exclusive possession. Secondly, you and Marcus may enforce the contract under equitable lease and use the remedy of specific performance because you have satisfied the three requirements to rely on specific performance. Finally, you and Marcus must remain in occupation of the property to show that you have secured the rights of the basement flat. This will bind Zain as the new purchaser to continue the previous agreement. I hope this may have helped you in solving your issues. Thank you, Ms. Sonia, for explaining all the challenges that we might be facing and recommendations to solve our issues.